Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzelli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. All right, here's a quick favor you can do for yourself. If you're even thinking about your case management setup, go take a look at this. E-Immigration is offering podcast listeners a free demo, and when you book through the Immigration Review podcast link, they'll donate $25 to the Casa Cornelia Law Center in San Diego. And yes, there's a bonus. Everyone who signs up will also get a free upgrade from the Essentials package to Complete. It's a win-win. So go to get.eMigration.com/IRP and check out a ton of free resources and book your demo today. Or, of course, click on that special link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and is intended to keep you up to date and enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello! So last week, I guessed at who argued the Sosnava-Rodriguez decision, the huge Fifth Circuit split decision holding that mandatorily detained Iwis in the Fifth Circuit must receive bond hearings within 90 days under the Constitution. I guessed who argued because the Fifth Circuit doesn't publish the attorneys in their day of decisions, and I don't have the bandwidth to go on to Pacer for all of these cases. Well, I was wrong to assume it was ACLU. It wasn't them, but they've been awesome and have won so many decisions protecting America. Rather, it was NIP and AIC, Emma Winger, Michelle Lapointe, Rebecca Kassler, Gracie Willis, Suchi Mathur, Ellie Norton, and Yul Landon. With Rebecca Kassler being the one who argued, I believe. And everyone, if you ever get a big win, feel free to send it my way and tell me who the attorney is. Most circuits publish who the attorneys are, but some don't, including the Fifth Circuit. Anyway, always happy to hear from all of you. Congratulations, NIP and AIC, but I hate to do it now, but as you surely already know, on Friday, the Fifth Circuit went en banc in Sosnava. Just awful. Gear up for round 2, due process warriors. I'll be praying for you. The cases are not quitting this summer. Another 9-case week. Let me breathe, courts. And actually, it's 11 because the BIA published 2 ACA decisions on Friday, which I simply cannot do, and will push to next week. Good Lord. Given all of this, new patron shoutouts are in order. Welcome to the Patreon fold, Elizabeth Kolar-Maya, Ramban Aquino, Shooting Chen, and Cole and Ebnet. I appreciate you guys more than you know. I am always an email away should you need anything from me. Thank you so much for your support. And with that rejuvenated spirit, I provide you your cases. All right, folks, let's do it. Fair amount of non-citizen good this week, so why not just start off with the Second Circuit? Aguilar-Villalobos v. Blanche, published by the Second Circuit on July 8, 2026. This case is about credibility and torture. Mr. Aguilar-Villalobos is from El Salvador and entered the United States without authorization at 21 years old. He was apprehended by CBP at that time, and he told them that he feared gangs in El Salvador because he had certain tattoos. Deemed to have a credible fear, he was released on bond and permitted to litigate his asylum claim in immigration court. Turns out he himself was a former gang member, and though he married a U.S. citizen and had a child, he fell in with his former gang in the United States and ended up getting convicted of firearms offenses in New York. Or maybe a firearms offense. Many of you at this point may have little sympathy for Mr. Aguilar-Villalobos, but we now learn some facts. Does it change your mind at all? He was brought here or sent here as a child. He attended high school in Los Angeles but dropped out in the 11th grade. In America, a gang forced him to join and get tattoos after he witnessed a gang member commit a crime because he, quote, already knew too much, end quote. Then he was marked for death for what appears to be some cooperation against that gang. He fled to El Salvador to avoid the U.S. gang, but came back after receiving threatening phone calls in El Salvador to essentially rejoin the gang and protect his family in the United States. That's why he came back. Quite the story if true, no? And they can get him in El Salvador too, which is why he fears harm there. An immigration judge didn't believe him, though, due to perceived inconsistencies in the record. Plus, the IJ deemed the firearm thing a particularly serious crime that barred him from everything except Convention Against Torture Protection. The IJ denied that, quote, given evidence that he would receive due process and that conditions in El Salvador's prisons reflected a lack of resources and training, end quote. The BIA affirmed, quote, El Salvador may detain the respondent to investigate his gang affiliation, but suspected gang members are allowed to appear before judges and those wrongfully detained have been released, end quote. The Second Circuit doesn't quite agree. It did affirm the adverse credibility finding, though. Material discrepancies in the record aren't necessarily required post-Real ID Act, but they are material here. The Second Circuit doesn't really get into the facts, but they exist, and the review is deferential, so there. Still leaves cat protection, though. Notwithstanding the conviction, by the way, thank you, Nasrallah. And Mr. Aguilar-Villalobos later filed a motion to reopen with the Board of Immigration Appeals, by the way, based, it appears, on how bad things got in El Salvador for former or current gang members due to the country's state of exception. And that's getting reviewed now, too. That is, the denial of the motion to reopen. Pretty important. Quote, the state of exception is a legal framework invoked by the government of El Salvador in March 2022 to temporarily suspend constitutional rights and enable mass arrests in response to gang violence, end quote. Important to remember, in the Second Circuit, quote, barbaric prison conditions might constitute torture if they cause severe pain or suffering and if circumstances indicate that the intent of the authorities in causing the severity of pain and suffering is to elicit, discriminate, punish, coerce confessions, intimidate, or the like, end quote. Nicely distilled. And here all agree that Mr. Aguilar-Villalobos will likely be detained if sent to El Salvador, as the BIA has readily admitted in some of its similar precedent of late for like individuals. The BIA erred here because it, quote, did not adequately consider the likelihood that Mr. Aguilar-Villalobos would be subjected to dire prison conditions and whether these conditions rise to the level of torture, end quote. Particular error given that there's some record support for this happening. What is the support, you ask, for your similar case? Well, a 2022 Guardian article noting that the government had been suspending constitutional rights and the presumption of innocence, a 2022 crisis group report describing how the government doubled the size of the prison population in just a few months and committed ill treatment, torture, and inmate deaths, a 2022 NBC News article describing horrific conditions inside the prisons, where deaths are stemming from unattended injuries, stabbings, and the like. Worse still, the BIA failed to consider, quote, whether the conditions in El Salvador's prisons were intentionally created and maintained or merely a result of a lack of government resources, end quote. That's a massively important thing to remember with all the BIA precedent coming out. Not enough for the BIA to just disregard terrible prison conditions without analyzing why they're terrible. Intent matters. Right, BIA? We'll get to that later in this episode. Maybe the next case. What record evidence supports that? That is, that this isn't just a lack of resources problem? Well, you got the 2022 NBC News article, noting that President Bukele, quote, tweeted the daily number of terrorists detained and talked tough about making their lives miserable, end quote. plus a 2022 Amnesty International article noting that, quote, the current government has seized control of the judiciary, enabling it to carry out its strategy of arbitrary arrests and mass illegal incarceration, unencumbered by checks or balances, end quote. All resulting in a quietly massive remand. So congratulations, Matthew K. Borowski, for petitioner. And that is Aguilar-Villalobos v. Blanche. Only one decision from the BIA this week, matter of RAN, published by the BIA. Although that's because I didn't do the two that were published on Friday, I will do them next week. This case is about nexus. And boy howdy is it harsh. Mr. RAN, Mr. Ran, is from Russia and fled that country in October 2022 when Russia's military mobilization and conscription orders began to intensify so they could invade Ukraine. It would seem that Mr. Ran opposes the Russian war in Ukraine and reasonably fears that he'll be forced into conscription in that country. Indeed, Russian military men hounded his mother for months about his whereabouts and eventually served her with a military summons for him. So, he's going to have to fight and possibly commit atrocities and die in Ukraine if he's returned there. Good enough for the immigration judge who decided to protect this man and grant him asylum. DHS hates it, and the BIA has now sustained DHS's appeal precedentially. As the BIA frames it, quote, at issue on appeal is whether conscription serves as a standalone basis for asylum in the absence of a nexus to a protected ground, end quote. I guess. Seems like there's a way in cases like this to add a political opinion claim. That was actually tried here, but the IJ found the fear not objectively reasonable on that basis. So the BIA has found the rare case where an IJ literally granted asylum based on forced conscription alone, and the BIA then used that to issue quite the harsh ruling that will surely be used to deny other conscription-type claims, even where maybe there's a better political opinion claim present. Who knows? I haven't seen the papers in this case, of course, and asylum was granted for God's sakes. And there are amicus mentioned in a footnote, so I'm positive that this fight was well fought. The would-be persecutor's motive is critical, explains the BIA, and several circuits have, quote, long held that military conscription is not per se persecution, end quote. String citing courts in a footnote. Now, it is true that forced conscription will rise to the level of persecution even under BIA precedent where a, quote, disproportionately severe punishment would result on account of one of the 5 protected grounds. Or where the non-citizen would necessarily be required to engage in inhumane conduct as a result of military service required by the government, end quote. But he's still got to establish nexus, persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. Calling the instances where a claim is viable, quote, exceptional, end quote, very rare, end quote, the BIA isn't going to let Russians fleeing for their lives benefit from U.S. hospitality. At least not this easily. Intentionally phrasing the issue to knock it down, quote, conscription is not a standalone 6th covered ground in the INA, end quote. Heads up in the Ninth Circuit, though, which, quote, has issued 2 unpublished decisions which suggest that a nexus to a covered ground is not required when considering the exceptions for those who would necessarily be required to engage in inhumane conduct, end quote. That's Razzouk v. Garland, 845 F Appendix 575, 9th Circuit 2021, and Cardoza-Herrera v. INS, 67 Fed 3rd 305. The first one of those is unpublished, but it looks like the second one is published, and the BIA clarifies that the BIA precedent they apparently rely on doesn't stand for what those decisions necessarily think they do. To win such a claim, then, a non-citizen, quote, must demonstrate that if conscripted, he himself would necessarily be required to engage in inhumane conduct on account of a protected ground, end quote. There's your rule. To me, the nexus stuff is what it is, but it does seem that the BIA has just made up that first part, that it's got to be required to do inhumane stuff, and is subject to challenge in the circuits. To the extent Mr. Ran relies on other case law from other circuits like the 11th Circuit, the BIA believes it based on a, quote, commonly used simplification, end quote, of asylum concepts and forced conscription. Ultimately, the BIA doesn't seem too concerned. It notes in a footnote, quote, draft evasion, particularly in time of war, is punished harshly by many countries, including the United States, end quote. I don't know, man. Seems to me we should be treating Russia's horror show in Ukraine a bit differently than America's military adventures abroad, but that's above my pay grade, and I'm definitely not getting into that here. The nexus requirement remains, and quite frankly, the BIA is implementing a fairly high and possibly impossible to meet evidentiary standard for a well-founded fear of persecution holding to, quote, would necessarily be required to engage in inhumane conduct, that is, conduct condemned by the international community as contrary to the basic rules of human conduct, as a result of military service required by the government, end quote. Pretty ironic too, right? Because if you came into court and argued that you'd met that standard for past persecution, you'd be immediately barred under the persecutor bar and probably arrested too, right? I feel like there's something to be done with that observation in a petition for review. Mr. Rand didn't meet the standard and so is having his asylum taken away. Let us hope the war of choice in Ukraine ends soon. By the way, not firmly resettled in Turkey despite what appears to be a significant stay in that country. So check out footnote 2 if you have such an issue. Appellate Immigration Judge Moulin concurred to make clear that the nexus analysis must focus on the victim and not the persecutor's political opinion, and that withholding of removal should be foreclosed on remand. And that is a matter of RAN. Next up is Lopez-Lopez v. Blanche, published by the 8th Circuit on July 7th, 2026. It's a short case about exhaustion, and I'm already exhausted. Are you exhausted? Claims here were not exhausted. Miss Lopez-Lopez has been in America a long time and sought non-LPR cancellation of removal in removal proceedings. But she was denied based on a finding that her Nebraska conviction for negligently abusing her stepdaughter was a crime of child abuse, abandonment, or neglect. If true, that will indeed bar the relief. The BIA affirmed that. On petition for review, she argued to the 8th Circuit that the agency was wrong because it, quote, relied on the wrong statute to declare her ineligible and overlooked the petty offense exception, end quote. Be honest, I don't know what that really means, but I suppose the argument is that the conviction can't be a crime of child abuse, but maybe should be a CIMT, but then meets the petty offense exception and so doesn't bar non-LPR cancellation? I don't know. The 8th Circuit has not given me any details here, and I don't quite understand the argument anyway if that's what is meant. I mean, it's either a crime of child abuse or it's not, right? Anyway, the 8th Circuit held that the CIMT thing, or whatever it was, wasn't exhausted because it wasn't made before the BIA. Quote, we may not address unraised issues when the proceedings before the IJ and the BIA were adversarial in nature and the petitioner was represented by counsel, end quote. Might be different for unrepresented non-citizens, explains the court in a footnote, but not sure. So, having apparently given up the crime of child abuse argument and not exhausting the other stuff, the 8th Circuit denied the petition for review. And that is Lopez-Lopez v. Blanche. Moving on is Guevara-Martinez v. Blanche, published by the 4th Circuit on July 8th, 2026. And we're going to get deep into crimmigration for two back-to-back from the 4th, both non-citizen friendly. This case is about particularly serious crimes. Judge Wilkinson dissented. Mr. Guevara-Martinez is from El Salvador and sought asylum and related relief and protection in removal proceedings. He fears the Zetas, a, quote, Central American transnational drug cartel, end quote, and one individual in particular who wanted to date his sister. But Mr. Guevara-Martinez's, quote, allegations are not simply far-fetched. They can only be described as fantastical, end quote. Yikes. So yeah, he's not going to be deemed credible on this one, folks. And because no one believes his story, I guess I'm not going to get too deep into it. He claims he found still beating hearts in a Zeta's garage that were being smuggled to the United States to be sold, for example. Then he moved to Guatemala where he was kidnapped by the Zetas. He started to pray during the kidnapping and, quote, the kidnappers were so moved by his commitment to God that they decided to set him free. They even gave him some money to take on his way, end quote. There's a gun chase through a building still under construction where he's shot, and then the Zetas kill his sister who that Zeta wanted to be with. More as well. More relevant to the particularly serious crime issue, Mr. Guevara-Martinez was convicted in 2023 of committing assault and battery against a family member in Virginia. Facts of that are kind of weird too, not gonna lie. But who knows, maybe it's all true. Seems like Mr. Guevara-Martinez has committed counsel, and he certainly has pro bono counsel for petition for review, and they put on an expert and everything below, so I don't know. Seems like he was decently impeached, though, about the facts of his conviction. And he was, of course, deemed not credible. We already know this. Importantly, though, the immigration judge denied everything except cat deferral based on a particularly serious crime finding. But also, the credibility stuff would tank asylum and withholding of removal separately, too. The BIA affirmed. The Fourth Circuit did not, on the particularly serious crime. Always terrified of judicial review, Oyl argued for the first time, as I've seen it, that, quote, because the ultimate determination of the applicability of the particularly serious crime bar is an unbound judgment call, we are precluded from reviewing the reasoning of the IJ. Not so, end quote. Sufficient questions of law on that one, folks. And in any event, this is about more legal issues than like the ultimate determination of whether a conviction is particularly serious. That is the question here. Unless a crime is a per se particularly serious crime, which this crime is not, step 1 of matter of NAM and the Fourth Circuit's Anor decision requires an analysis of, quote, whether the elements of the offense bring it within the ambit of a particularly serious crime, end quote. That is a threshold analysis. The IJ held that it was met simply because this was a crime against a person, but that's insufficient, explains the majority. IJs need to analyze the elements of the actual conviction statute at step 1 and explain why those specific elements fall within the ambit of particularly seriousness. Restated, it is not the case that all crimes committed against persons will be particularly serious. You need to focus on the elements, not so dissimilar to the categorical approach. And in any event, the IG here only even made that observation after discussing the facts of the conviction, which is the reverse of what matter of NAM and Anor allow and indeed require. As such, remand. On credibility, though, it's totally getting affirmed, so it might be a short-lived victory. Quote, abundantly clear, end quote, that a proper adverse credibility finding was made to the court. And the IJ provided Mr. Guevara Martinez sufficient opportunities to explain himself. That then leaves only cat protection. So kind of what's the point of the particularly serious crime remand? Whatever, I'll take the non-citizen-friendly precedent, I'm just kind of curious. And the cat denial is getting affirmed too. So much of the claims depend on the truth of Mr. Guevara Martinez's story, which the Fourth Circuit just doesn't believe. So too, the relevant portions of the experts' testimonies depends on Mr. Guevara Martinez's credibility. As to the state of exception in El Salvador that we already discussed on this episode, well, not really relevant to non-suspected gang members like Mr. Guevara Martinez to the court. At least not enough to overturn the IJ and the BIA. So it's a remand with no relief really available unless, I guess, the Fourth Circuit is implicitly holding that a non-citizen can obtain asylum or withholding of removal, notwithstanding an adverse credibility finding? So that's how I choose to read it, in the end. Again, Judge Wilkinson dissented. But it all means congratulations, Ariel Alyssa Rosenbaum and others from Covington and Burling for petitioner. And that is Guevara Martinez v. Blanche. Moved on to Ramos v. Blanche, published by the Fourth Circuit on July 9th, 2026. And not my partner Ed Ramos, a different Ramos, a Mr. Ramos from Honduras, who is a lawful permanent resident. But he took scrap metal wiring from his employer and traded it for cash at a recycling facility, netting $46,000 for all the defendants. Ed Ramos would never do such a thing. And that's not like a huge windfall, particularly if he's got multiple co-defendants, but also, yeah, very illegal, don't do it. Not saying you should do it. Seems like poor choices were made all around. Convicted for embezzlement under Virginia Code Annotated Section 18.2-111. The statute criminalizes a whole lot of things, which we'll get to in a sec. The IJ and the BIA held that it matched the definition of an I&A Section 11843-MI aggravated felony, meaning that Mr. Ramos loses his green card. The Fourth Circuit disagrees. And in only 11 pages for this regularly uber-complex removal statute, wins all around for everyone. Although not entirely for Mr. Ramos. Quote, while the appeal was pending, the government mistakenly deported him. The government brought Mr. Ramos back. The government also assured us that its error hadn't impacted Mr. Ramos's removal proceedings and represented that it had implemented safeguards to ensure this sort of error will not happen again. End quote. That was during his appeal to the BIA, which is very wrong. And then he got removed after the BIA ruled against him while the petition for review was pending. Pretty rough, but he's coming back. Again, as an LPR. So, not an aggravated felony. Here's why. This aggravated felony provision only includes fraud or deceit crimes. That analysis requires application of the categorical approach. Quote, fraud means an intentional perversion of truth for the purpose of inducing another in reliance upon it to part with some valuable thing belonging to him or to surrender a legal right or a false representation of a matter of fact, whether by words or by conduct, by false or misleading allegations, or by concealment of that which should have been disclosed, which deceives and is intended to deceive another, so that he shall act upon it to his injury. End quote. In retrospect, I probably shouldn't have quoted all that. You're probably not even listening anymore. And fraud also requires an intent to deceive or trick. Now, deceit means, quote, the act or practice of deceiving, like by falsification, concealment, or cheating, end quote. And fraud and deceit, quote, must involve trickery, misrepresentation, or intentional concealment, end quote. Now, don't get everyone wrong. This crime probably involves fraud or deceit, the thing that actually happened, the scrap metal stuff. But the categorical approach only cares about the embezzlement statute itself of conviction. What's the least culpable conduct required for such a conviction? Well, quote, what Virginia calls embezzlement is essentially a form of larceny that begins with the perpetrator lawfully possessing the stolen property, end quote. Larceny is theft, and theft doesn't necessarily involve fraud or deceit. Quite the opposite, actually. It usually doesn't. Ain't gonna cut it, and good to remember, quote, conduct isn't fraudulent or deceitful merely because it's unethical or dishonest. It must involve a fraudulent or deceitful action, end quote. It's for this reason, for example, that the Supreme Court has held that tax evasion is not necessarily fraudulent or deceitful. This despite the fact that the Virginia statute itself uses the word, quote, fraudulently, end quote. I'm sure the oil attorney loved that at first, until they saw the briefing of petitioner. Quote, Virginia's High Court has explained fraudulently under the embezzlement statute means wrongful or felonious intent, end quote. It has nothing to do with fraud, actually, as that term is understood in federal court. And that's kind of a big deal for Virginia folks. To the extent prior old Fourth Circuit precedent has implied otherwise about embezzlement in dicta, that's not a good reading of that prior dicta anyway. Nor is concealment always required to convict in Virginia, which would probably then equate to fraud or deceit if it did. Getting out of the theoretical for you folks, quote, here's one unlikely example. Say that you deliver your car to a valet to park while you have dinner. If the valet instead steals the car, he wouldn't be any less guilty of embezzlement if he called and told you before driving off. The statute, by its elements, criminalizes the unauthorized taking of another's property. It is agnostic on whether the embezzler tells his victim, end quote. So that's a victory for the non-citizen again, getting his green card back, it seems. And I certainly don't want to give the administration any ideas, but what is the point of this whole I&A scheme if Marco Rubio can simply make up a foreign policy excuse, write a letter, and get a green card taken away? Asking for a friend, but also for our firm's own case that we are currently litigating. I don't know. Seems like a wildly unconstitutional statute to me that is I&A Section 237A4C. For another day. Because for now, congratulations to Benjamin Winograd and Rosanna Roland Grau for petitioner, along with some wicked smart Harvard law students on amicus. I spared you all from doing my Boston accent. I almost did it. You probably even heard it come out a little bit. And I've got something else for you too. Mr. Ramos had a U.S. citizen daughter over the age of 21. She filed an I-130 petition for him. Easily approvable, and once approved, he'd be eligible to readjust in immigration court because aggravated felonies don't bar adjustment of status. He might have a problem if the conviction is also a CIMT, but there's a waiver for that too if he has the qualifying relative. But I-130 adjudication is now taking forever, and the immigration judge in this case ultimately didn't give USCIS enough time to decide it. Pretty wild procedural due process violation, if you ask me, and I'm not necessarily blaming the IJ either here for multiple reasons. The I-130 was ultimately approved during the BIA appeal, but then that would require a motion to remand or motion to reopen. Anyway, all of that's irrelevant because he's not removable, but the Fourth Circuit doesn't seem pleased with all this. For next time in the Fourth Circuit. And that is Ramos v. Blanche. You didn't go to law school to enter data. I know I didn't. Yet here you are. H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. Because you deserve a practice that grows without burning you out. Our next decision is I&N Dec v. Blanche, published by the 7th Circuit on July 1st, 2026. This case is about asylum and particular social groups. I missed it last week. I apologize profusely. But these weeks are massive and are literally starting to bleed together anyway, so there you go. Mr. Andrić is from Serbia. I have heard and read about some terrifying things with the soccer hooligans in that country. That many are operating as criminal enterprises and that soccer hooligans is quite the mislabeling. He based his claim here on his asserted membership in the particular social group of, quote, Serbian soccer players who are the victims of violence from soccer hooligans who are unsatisfied with their play, end quote. Bit of a mouthful, I'll concede. He had a political opinion claim, too. And he was beaten to unconsciousness after his team tied with a rival team. Quote, he awoke in a hospital where for approximately 2 days he was treated for moderate facial burns, a skull hematoma, and a mild concussion, and then discharged with instructions for home care. End quote. He went to go play for a team in a different city but received 3 threatening phone calls from the hooligans, and he was stalked after practice one day despite moving cities. He didn't report any of it out of fear that the hooligans were connected to law enforcement. He ended up in America and applying for asylum where an immigration judge held that it wasn't bad enough to be past persecution and that in any event the particular social group isn't a particular social group. And it wasn't on account of an anti-hooligan type political opinion either. And no showing that the police were unable or unwilling to protect him. The BI affirmed and waived Mr. Andrić's attempt to actually assert a claim based simply on his membership of the particular social group of former soccer players in Serbia, so narrowing that group on appeal. And so here we arrive. The 7th Circuit affirmed the BIA. The harm might rise to the level of past persecution. It might not. The 7th Circuit doesn't need to get there because it doesn't see a nexus to a protected ground. Important, though, the 7th Circuit says that its prior case law that it reviews whether a particular social group is actually a particular social group is a question of law that it reviews de novo, and that appears to remain good law, notwithstanding the Supreme Court's Ores Oriana holding that past persecution generally is reviewed for substantial evidence. So that's not nothing. Being a soccer player, though, isn't immutable, which is one of the 3 particular social group elements. Probably why Mr. Andrić was arguing for the former soccer player group on appeal, right? Mr. Andrić actually conceded this in the 7th Circuit brief, it seems, that is that the first group isn't a group. That said, in a footnote, the 7th Circuit does muse that, quote, it might be true for many people that their occupations are not such fundamental parts of their being that it would be unreasonable to expect them to change their occupation to avoid persecution. For others, however, a career may be fundamental to their personhood because of, among other things, something that makes the work integral to their identity, the number of years of training, the non-transferability of the skills, or because of the artistic, political, or religious nature of the job, end quote. So that's something. String citing other circuit precedent, too, that is, jobs can be immutable. Just not even at issue here in this case. So yes, onto the former soccer players group, it was waived because Mr. Andrić didn't assert it before the IJ. And it is distinct enough from the first group that it had to be raised. Heck, that's why he's raising it on appeal, right? Reasons the court. The 7th Circuit thinks it would fail anyway on nexus, quote, any harm Mr. Andrić fears in either case stems from personal and performance-related grievances, not from membership in a cognizable group. After all, he does not claim that if he returned to professional soccer and consistently led his team to victory each game, he would still face harm from the hooligans, end quote. And it's now been 10 years since the events, after all, reasons the 7th Circuit. Doesn't seem like the hooligans would care about him on account of his being a former soccer player, if at all. The 7th Circuit deems Mr. Andrić's anti-hooligan political opinion claim waived because he failed to brief it, which is too bad. Doesn't seem to believe it in any way based on how it describes the arguments before the IJ. So, no particular social group and no nexus. While that should be the end, the court provides one last discussion, and it is important. Mr. Hendrick argued that the immigration judge didn't engage in reasoned decision-making. Quote, in recent years, immigration judges have been appending a boilerplate addendum of law to their decisions and incorporating it by reference. Often, as is the case here, the individual decision itself contains little, if any, citation to case law. End quote. We've all seen this, right? And the Seventh Circuit doesn't seem to like it. Indeed, quote, certainly we would not accept a brief that set forth the facts and legal conclusions in one document and then invited us to dig through a boilerplate addendum for the supporting law, end quote. Gotta actually connect the facts to law. That's judging and lawyering. IJs need to shape up in the Seventh Circuit, quote, egregious failures of the Immigration Court and the BIA to exercise care commensurate with the stakes in an asylum case can be understood, but not excused, as consequences of a crushing workload that the executive and legislative branches of the federal government have refused to alleviate, end quote. Asylum seekers present, quote, serious matters warranting serious consideration and full due process, end quote. Not relevant to the ruling here because the court agrees with the agency that an asylum claim cannot stand, but a shot across the bow for that legal addendum stuff in the Seventh Circuit for sure, and the first that I or the Seventh Circuit, I think, has yet seen. There will likely be more. And that is Hendrick v. Blanche. Sticking with the Seventh Circuit, we have EEV et al. V. Blanche, published by the Seventh Circuit on July 6, 2026. The Seventh Circuit has officially entered the Riley party. Recall there had been some ambiguity about what the Seventh Circuit was up to on all this? It has now answered with a split decision. Judge Brennan dissented. It's quite the long one. And unlike the Farrow decisions of late, which was also the exact context that Riley arose in, this one's arising in the context of a reinstated removal order. The Seventh Circuit starts out by outlining the three types of ways that this can get to a circuit, that is, withholding only claims separate from traditional removal proceedings. ICE can expeditiously order certain non-citizens removed, or you've got the Farrow context and the withholding only proceedings that follow, or you've got reinstatement of a long final order of removal, and then subsequent withholding only proceedings. Interesting enough, but honestly, I just read that so I could read this footnote in full, which taught me something completely new. Quote, there is one limited exception. When a person subject to expedited removal claims to have a status as a lawful permanent resident, refugee, or asylee, or claims to be a U.S. citizen, and the immigration officer cannot verify that claim, the officer will issue the expedited removal order and refer the person to an immigration judge for review of that claim and not any other issues. If the person proves his or her claim, the expedited removal order is vacated. The IJ's decision cannot be appealed to the BIA. See 8 CFR section 235.3b5, end quote. How about that weird thing? Did you know that? I bet you didn't. The Seventh Circuit goes through all the various first three processes in depth and how they might arrive in withholding-only proceedings. So, the I&A tethers circuit review to a, quote, final order of removal, end quote, but does not otherwise really define that phrase. But we do know that a petition for review must be filed within 30 days of a final order of removal. Now, in the case of a reinstated final order of removal and withholding-only proceedings that follow, it used to be that the 30-day clock began when withholding removal and CAT were denied in withholding-only proceedings. Riley potentially changed all that. We'll get to timeliness in a sec. Because of the Seventh Circuit majority, the Riley majority also held that its new rule wasn't jurisdictional. That is, the 30-day deadline post-final order of removal to petition for review is a mandatory claims processing rule. So we've got the non-citizens here. Many, actually, they were consolidated into this case. Miss EEV, for example, is from El Salvador, and she was expeditiously removed in 2007, re-entered without authorization in 2015, and was caught. DHS reinstated the 2007 final order of removal, but because DHS decided she had a reasonable fear of persecution, she was placed in withholding-only proceedings before an immigration judge. Those proceedings actually remain pending. Freaking out because of the new Riley rule, though, Miss EEV petitioned for review the reinstatement of the 2007 removal order less than 30 days after Riley, but of course well more than 30 days after the reinstatement itself. As to Miss MCCG, another petitioner here, she's from Mexico and her situation is arising in a Farrow context. So this decision also does adjudicate the Farrow issue. She didn't pass her reasonable fear review and sought review of that before an IJ, and that was still pending when she too petitioned for review the Pharaoh within 30 days of Riley, but well after 30 days of the Pharaoh itself. Ultimately, she got her withholding hearing, or maybe the reasonable fear hearing, I don't know, but she did not succeed. Lots and lots of other non-citizens too, with similar cases being decided all at once, mentioned in a footnote. The Seventh Circuit majority is going to give it a review. First, the jurisdictional issue. We don't have a problem here, like we did in the 11th Circuit case a few weeks ago, where the removal order-like thing was not petitioned for review. Because here they petitioned for review the reinstatement order and the Pharaoh, right? But still, Oil's making a no jurisdiction argument, even though they were petitioned for review. Oil first argued that as to Miss EEV, the reinstatement isn't a final order of removal that permits petition for review. Rather, Miss EEV would have to petition for review the 2007 removal order, which of course would be decades untimely. Not only does such a rule overturn Seventh Circuit precedent and contradict law in other circuits, but, quote, if we were to adopt the government's position, we would foreclose judicial review of questions of law and fact arising from reinstatement orders, including entitlement to cat protection and even claims of mistaken identity and U.S. citizenship, end quote. Court's not going to do that. Seventh Circuit also believes that the I&A's jurisdictional zipper clause permits this, but it's also being practical. For Oil, right, quote, there will be no judicial review of whether the government has the right person. The court believes the I&A's jurisdictional zipper clause permits this, but is also being practical. The court believes Riley supports this too, believing that Riley actually expanded what a final order of removal is, including within its scope, quote, an order with the same characteristics, end quote, as a historic removal order, I guess. Reinstatement, as limited as that inquiry is, fits the bill because it's all about actually removing the person, as well as determining whether that person is the removable person. In effect, reinstatement executes a final order of removal, and that is removal order enough for review to the majority. Very important to keep federal court review, too, given how many habeas-type claims the I&A limited in 1996, funneling it all through the petition for review process, explains the court. Not hypothetical either. String-citing circuit claims where a reinstatement challenge avoided the wrongful removal of a U.S. citizen. Not for nothing, it appears that the court doesn't trust the Trump administration to faithfully execute the law and apply a new, powerful rule in good faith, should the court now limit jurisdiction. So it's not going to do it. Nor were these petitions for review filed too early, as Oil alternatively argued, in direct contradiction to its first argument. Silly argument, and I won't get into it further. Riley itself recognized that non-citizens can petition for review the reinstatement or the Pharaoh, what have you, and ask the circuit to hold that petition for review in abeyance to wait out the conclusion of withholding-only proceedings so you can petition for review the denial of withholding of removal and cat protection too. It is a terrible procedural rule, but that was Justice Alito's suggestion. And it does seem the Seventh Circuit majority, at least, will be fine with pro forma initial petitions for review to placehold in case withholding and cat are denied. Still dangerous stuff, though, guys. Though in a footnote without explanation, the Seventh Circuit says that the argument that a substantive challenge to removability is required is foreclosed by Monsalvo v. Bondi out of the Supreme Court a couple years ago. I must have missed that part. But a must read if you're playing this petition for review of withholding-only game, folks. And on this, the Seventh Circuit pretty much splits from the Ninth and 11th Circuits in Navarrete and Hales, respectively. Strong words against Navarrete, too. And I've heard they might be going in bonk in the Ninth. More importantly, the Seventh Circuit believes that, quote, Congress has confirmed more than once that cat orders are subject to judicial review, end quote. Would be kind of weird to take it all away like 30 years later now, right? As to timeliness, well, it's a long decision and I'll start speeding up. Normally, the non-citizens here might have been in trouble, but Riley was extraordinary, and then they petitioned for review within 30 days of Riley. Equitable tolling is always available for these type of cases anyway, explains the Seventh Circuit, and it was met here. And then the Seventh Circuit cites 1.5 pages worth of district court decisions finding DHS operating in bad faith to try to take away non-citizens' right to federal court access, thereby supporting an equitable tolling rule. Pretty wild. For example, in addition to Kilmar Abrego Garcia, of course, this list apparently includes, quote, dumping the non-citizen onto the street hundreds of miles from home without her personal property or identification documents, end quote. with other non-citizens, and the Seventh Circuit doesn't think they're DHS mistakes either. Indeed, interesting to me in other contexts, it's possible that, quote, reliance on binding precedent that is later overruled can qualify as an extraordinary circumstance to justify equitable tolling, end quote. Nor is venue appropriate in the Fifth Circuit just because that's where, in Miss EEV's case, the reinstatement order was issued. Rather, venue travels with where the IJ completes withholding-only proceedings, which, by the way, I guess haven't even happened yet, but they will in the Seventh Circuit eventually? Interesting and weird. Right, because if for some reason withholding-only proceedings leave the Seventh Circuit for venue, this whole decision will have maybe been issued in error? Again, it's Justice Alito's wild rule that's starting and causing all this, but, that's what we got. But the Seventh Circuit wouldn't transfer anyway, it says. Seems like pro bono counsel is involved, so congrats to everyone fighting such a complicated, important fight. I hope I distilled that well. It's a very complicated issue. And that is EEV et al. V. Blanche. Concluding with two from the Ninth Circuit, first, Sar v. Blanche, published by the Ninth Circuit on July 7th, 2026. This decision is about particularly serious crimes and matter of YL. And Loper Bright. Multiple daggers to my heart, this one. Mr. Sar is from Gambia and became a lawful permanent resident of the United States as a young man. Many years later, he was convicted in the District of Utah for one count of conspiracy to distribute methamphetamine in violation of 21 U.S.C. Section 841A1 and 846. Everybody agrees that it's a drug trafficking aggravated felony, and it makes him removable. He applied for asylum and related relief and protection based on, quote, his alleged fear of being harmed by radical Islamists upon his return to the Gambia, a supermajority Sunni Muslim country, end quote. Mr. Sar, you see, is technically Muslim but identifies as spiritual. He's also a musician and has appeared on radio stations in Gambia. In one such interview, he, quote, told the interviewer that he believes in heaven, but not in the way the Quran describes, because he cannot believe in a city of jewels where a river of milk and honey flows beneath and a reward of I&N, wives, whose beauty surpass everything beautiful one can imagine, end quote. After that interview and that admission, 8 men led by an imam came to his family home and told him that there was a fatwa issued to kill Mr. Sar. And they slapped his mother. Asylum's gone because it's an aggravated felony, but he received 2 years in prison for the conviction, so it's not a per se particularly serious crime for withholding of removal purposes. But then in comes a matter of YL. We'll get to that in a sec. The IJ denied withholding of removal based on a particularly serious crime finding and denied cat deferral on the merits. The BIA affirmed. As did the Ninth Circuit, affirming the cat denial in a concurrently filed unpublished opinion, so we're not going to get into it. To recap, an aggravated felony qualifies as a particularly serious crime that bars asylum. An ag-fel or felonies where the aggregate term of imprisonment is 5 years or more constitutes a per se particularly serious crime for withholding of removal purposes too. So pretty high bar, reasoned Congress. Nevertheless, that isn't the end-all be-all, and the BIA has made it much easier to deem a conviction a particularly serious crime through matter of NAM and its precedent. Again, notwithstanding the high statutory bar. Quote, this analysis begins with the BIA determining whether the elements of the crime of conviction potentially bring the crime into a category of particularly serious crimes. If so, the BIA then considers all reliable information in analyzing the remaining 2 factors. End quote. Important to remember that is that the first NAM step is elements-based. We talked about this hours ago in the Fourth Circuit decision. And with NAM and the rest, 45 years of precedent counsel that the particularly serious crime analysis must be done on a case-by-case basis, individualized. And recall, there are literally no particularly serious crimes delineated by statute or regulation. Yet in matter of YL, Attorney General Ashcroft created a presumption that drug trafficking crimes are particularly serious. Heck, even murder isn't presumptively particularly serious, but what the heck, the Attorney General said, let's do it for drug trafficking crimes. Gotta be a drug trafficking conviction, though. But if it is, the Attorney General just kind of made a bunch of things up, all of which must be met, or else the conviction is gonna be a particularly serious crime that bars even withholding of removal. To rebut that presumption, reasoned the Attorney General over 2 decades ago, the conviction would need to, 1, involve a very small quantity of a controlled substance, 2, involve a modest amount of money paid for the drugs, 3, be merely peripheral involvement of the non-citizen in the criminal activity, 4, There must be an absence of any violence or threat of violence, implicit or otherwise. 5, there must be an absence of any organized crime or terrorist organization involvement. And 6, there must be an absence of any adverse or harmful effect of the activity or transaction on juveniles. All those elements must be met, all 6, and it still might not be sufficient, even if they're met. It's all up to the IJ. So it's almost a near impossible presumption to rebut, particularly as a drug trafficking conviction that is actually prosecuted will probably never involve a very small amount of drugs these days, or a very modest amount of money, right? Whatever that means in 2026, by the way. Although the Ninth Circuit does point to one unpublished decision from the Third Circuit where an IJ found the presumption rebutted, so there you go. Mr. Sarr didn't meet it. Thousands of dollars and quite a bit of meth were involved in this conviction. So he's challenging matter of YL itself as violative of the INA, which, recall, requires a case-by-case analysis of a particularly serious crime and doesn't create categories of particularly serious crime presumptions. Problem for Mr. Sarr is that the Ninth Circuit already deferred to matter of YL years ago in Miguel v. Gonzalez. But as it was 2007, the Ninth Circuit did so by relying on Chevron deference, rather than on its own determining whether matter of YL is the best reading of the particularly serious crime statute, as Loper-Bright would now require. And so herein lies the first dagger to my heart. The Ninth Circuit held that stare decisis completely precludes the panel from concluding opposite Miguel because of that language from Loper-Bright itself, where the Supreme Court said that it wasn't throwing into doubt the cases that had relied on Chevron deference in the past. Again, I've always argued that the Supreme Court was talking about its own decisions and not the circuit cases, and that additionally the whole matter remained just a bit unclear to me in the Ninth Circuit too. But not really anymore. First, actually, the Ninth Circuit rejected the very smart argument that regardless of all of it, the particularly serious crime analysis still requires an independent finding that the non-citizen is a danger to the community. And that argument comes from the statute itself. The problem is that the BIA case law seems to have long ago held that dangerousness gets wrapped in with the analysis of the crime itself, that is, the NAM and matter of Frantescu analyses. And in any event, matter of YL's presumption broadly covered everything, flat-out ruling that no further analysis under Frantescu is required for drug trafficking crimes. That all alternatively brings Mr. Sarr in direct conflict with matter of YL, meaning really Miguel, arguing that the panel can and should vacate it using Loper-Bright, but it can't and won't, explains the court. And word up, Mr. Sarr's counsel, quote, Mr. Sarr contends that the court's statement in Loper-Bright addressed only prior decisions of the Supreme Court and not prior decisions of the lower courts. But we have not understood it that way, end quote. I have, though, Mr. Sarr's counsel. I have. You got me. And I think Judge Bumate, if I'm remembering correctly, in the Ninth Circuit. Quote, our holdings that specific agency actions are lawful were not overruled by Loper-Bright simply because they relied on Chevron, end quote. I feel like there was a case last year where the Ninth Circuit seemed to have said or implied that actually the only thing stare decisis prevents is determining this exact issue differently from the prior decision. That is, that the panel couldn't hold that the exact statute here isn't a particularly serious crime if a Chevron deference case already had with the exact statute, but that everything else, like the analysis, including YL, is fair game? I don't know, it might be misremembering or even over-remembering. I have been known to do it. But it wasn't discussed by the panel anyway. Petition denied, and 2 big non-citizen-friendly arguments rejected by the Ninth Circuit in a very complicated decision. And that is Sarr v. Blanche. We conclude with Manhivar Ayala et al. V. Blanche, published by the Ninth Circuit on July 9th, 2026. This case is about ineffective assistance of counsel. Seems like this is a family of asylum seekers from Honduras who had their case denied by an immigration judge and then affirmed by the BIA on December 19, 2023. The BIA mailed that decision to the petitioner's attorney and mailed them, the petitioners, a courtesy copy. But the attorney didn't read the mail immediately and for whatever reason didn't inform the petitioners until March 5, 2024. So a long time after and well past the 30-day appeal period. New counsel came in, alleged ineffective assistance, and on that basis asked the BIA to reissue its decision so they could petition for review to the Ninth Circuit. The BIA declined the invitation. Just said, flat out, we can't do it, because the ineffective assistance happened after the BIA issued its decision. Not our problem, said the BIA. Plus, recall, the petitioners were served a courtesy copy. The Ninth Circuit doesn't like that. First off, quote, when a lawyer's error results in a non-citizen being denied the right to appeal altogether, we apply a presumption of prejudice, end quote. So that's already half the battle for an ineffective assistance of counsel-based claim. The first is, was counsel's performance deficient? Obviously it was here, but it was post-BIA order, remember. Here's the thing, though. Careful listeners may have already identified. On episode 268, the Ninth Circuit said, in Levy Bondi, that an ineffective assistance of counsel claim lies in cases like this, that it doesn't matter that the ineffective assistance happened post-BIA order. Quote, the BIA is not required to exercise its discretion to review the ineffective assistance of counsel claim, but it must provide a reasoned explanation for declining to do so. This is especially true where, as here, a counsel's alleged deficiencies deprive an immigrant petitioner of any meaningful appellate review of his or her claims, end quote. And remember, we've already got the prejudice per se, right? Quote, the BIA's bare statement here that under the circumstances it is not for us to circumvent a congressionally imposed deadline limiting the authority of a different tribunal is not a legitimate rationale for declining to review the petitioner's ineffective assistance of counsel claim, end quote. Lee might be why Oil put so much into arguing that it was all excused because the non-citizens received that courtesy copy, which of course had the 30-day deadline in it as well. I don't know, seems like a good argument. But yes. The Ninth Circuit is smarter than me. The first prong of ineffective assistance of counsel is diligence, and there's no question that the motion to reopen was diligently filed here. So you've got both ineffective assistance elements, right? Diligence and prejudice. Quote, the BIA nonetheless rejected petitioner's ineffective assistance of counsel claim, concluding that the courtesy copy mailed to the petitioners provided sufficient notice of the filing deadline and the ineffective assistance of counsel claim did not alter this conclusion. In doing so, the BIA necessarily implied that petitioners could not have been prejudiced by counsel's failing so long as they received a courtesy copy of the BIA's decision, end quote. But that's not right. Prejudice is kind of already assumed for cases like this, right? Nearly. And it is now. Quote, we hold that service of a courtesy copy of the BIA's decision on petitioners is not sufficient to rebut the presumption that their counsel's deficient performance caused them prejudice, end quote. Non-citizens are allowed to rely on their attorneys, explains the Ninth Circuit. That's why they hire us, explains the court. Quote, it rationally follows that non-citizens cannot be precluded from demonstrating ineffective assistance because they reasonably relied upon and assumed their counsel's competence, end quote. Immigration is uber complicated, reasons the court, and so non-citizens can rely on the attorneys that they hire. Heck, it's for this reason that the BIA regulations require service on counsel when the non-citizen is represented, says the court. The BIA should have applied the presumption of prejudice here. Probably should have granted the motion too, so the Ninth Circuit remanded. And therefore, congratulations, Zachary Diaho for petitioners. And that is Menivar Ayala et al. V. Blanche. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.
you.